Hi, it's Roland Jones. This is another short video in a series of videos on preference and fraudulent conveyance issues. This case deals with the defense of contemporaneous new value. The issue is that there has to be value at the time of the transfer, and I'll go into more details. Okay, so a few gentlemen extended a loan to the debtor pre-petition, and the debtor delivered a promissory note to these creditors as security for the loan. Then the debtor transferred a security interest in his business assets during the preference period. Debtor goes bankrupt, trustee is appointed and sees a transfer of a security interest during the preference period and decides that that's a transfer of value and a preference, and he sues the defendants to avoid the transfer. The creditors argue, well, this was a contemporaneous exchange because the security interest was transferred in exchange for the creditors releasing another security interest in a boathouse owned by the defendants. I'm sorry, owned by the debtor. And so basically the defendants are arguing this is just a contemporaneous exchange. We gave up a security interest in a boathouse, and he gave us another security interest. It's a contemporaneous exchange for value. It cannot be a preference. So the main issue before the court was whether the security interest that was transferred was avoidable as a preference, or was it covered by the contemporaneous exchange defense? The applicable code section is 547C1, which covers contemporaneous exchange. And what this defense says is that even though you received even though the defendant in a preference action received a transfer, in this case a security interest, just because property was transferred during the preference period doesn't mean it's necessarily avoidable as a preference. To the extent that such transfer was intended by the debtor and the creditor, to or for whose benefits the transfer was made, to be a contemporaneous exchange for new value, and was in fact a substantial contemporaneous exchange. So that section says, look, if you receive a payment or a transfer of something of value during the preference period, if you also exchanged for that property something of equivalent value, then what the section is saying is that other creditors are not prejudiced because you're getting something, but you're giving something back contemporaneously. Unsecured creditors are prejudiced when one creditor gets paid 100 cents on the dollar during the preference period, and then there's a bankruptcy filing, and all the other creditors get pennies on the dollar. That's the purpose of the preference laws, is to avoid that situation. But here, where there's a contemporaneous exchange, there's a payment, but that creditor also gave something up contemporaneously. So it's merely a tit for tat situation. So the court took a close look at this and decided there was a problem. What these creditors gave up in exchange for the security interest they got was a security interest in a boathouse. But there was a reason they gave that up, because the debtor really didn't have good title to the boathouse. So they weren't really giving up something that had any value. The security interest in the boathouse was only released when they found that it wasn't worth anything. It didn't have good title to the boathouse. So the transfer was not protected because the value that the value of the security they released was not equivalent to the value that they received. In conclusion, if you're going to argue contemporaneous exchange, there's got to be you got to give new value. You have to give value. Giving up a security interest in a boathouse that the debtor doesn't have title to is not equivalent value.